Good morning, everybody, and welcome back to the Law and Crime Network. Thanks for joining us. I'm Jesse Weber. We are entering into day 3 of the Laquan Barrow, Gary King, and Michael Smith case out of Florida. This case, which we all thought seemed pretty straightforward, 3 defendants, seemed like the police had some pretty strong evidence against them. The state was going to put on a strong case. Yesterday was so crazy. I have to preview everything that happened as we wait for a live feed in the courtroom today. As soon as we do have a live feed, we'll make sure to go to it. But I have to tell you everything about this case in case you missed it. So again, these 3 men, they're each charged with 1 count of second-degree murder in the death of 19-year-old Benetria Robinson in a 2015 nightclub shooting out of Florida. The nightclub is called the Cloud 9 nightclub. Barrow and Smith are also charged with 5 counts of attempted second-degree murder, while King is only charged with 4 counts of attempted second-degree murder. Now, they are all tried together, but it should be noted that Mr. King has a separate jury. So there are 2 juries in this case. We'll talk a little bit about that as well. Now, yesterday was such a bad day for the prosecution. And why was it such a bad day? Because 2 of their key witnesses did not provide the kind of testimony that they were hoping for. First, one of the state's key witnesses, Christopher Jones, actually refused to testify. He refused to testify even after being subpoenaed and ordered to do so by the judge. He refused to testify. He was placed in contempt of court, and all of his testimony, which we knew about from police interviews where he positively identified Laquan Barrow as a shooter in this case, the jury didn't hear any of that. They didn't hear any of it. Then there was a second witness, Dontarius Bartley. Now, Mr. Bartley was actually one of the victims in this case. And what did he say? He said he had lied to police. He said that he felt police pressure and that he made up a story. So all of his testimony about who the shooter was and what he saw about Mr. Barrow being the shooter, that wasn't heard directly from him. And for the prosecution, they had to bring in a police officer who testified about the interview that he had with Mr. Bartley. But again, not having that firsthand account is really not looking so good from the prosecution's standpoint. Compound that on the fact that also we learned yesterday there was no DNA, there was no fingerprint evidence, there was none of this on any of the 21 shell casings found at the crime scene. So what we were left with yesterday is that there was gunshot residue. A gunshot residue test was conducted on Mr. Barrow, and they found 1 particle consistent with gunshot residue on his right hand, but nothing on his left hand. Now, all of this compounded shows that the prosecution didn't really have a very strong day, and I want to talk about it a little bit as well. What they were able to establish was that there were 3 guns that may have been fired in connection with this crime. You have 3 defendants. Logically, it would seem that each one of them was holding a weapon. But if that's all they have right now, it's looking a lot stronger for the defense than it is for the prosecution. So to help me dissect everything that we've learned so far in this case, I'm joined by criminal defense attorney Brian Wagner. Brian, great to have you back here.
Jesse, thank you for having me.
I don't even know where to start. I think where we have to start is obviously from Mr. Jones refusing to testify. Pretty shocking, right?
It is. And anyone that ever says no trial attorney will ever tell you every case is a ground ball. Every case has its ups and downs and things that you can't possibly plan for. This is one of those things.
So he had some key testimony that we were all waiting for. I'm going to tell you a little bit of it, and then I'm going to show you what happened in the courtroom. He basically said that he was there that night, that he saw the altercation between Danielle Kendrick and Maisha Barrow. Remember, this all started as a fight between 2 women. He saw that Mr. Barrow and Mr. Kendrick were there was a fight about to start, and he heard Laquan Barrow say, "I've been sparring y'all because of Marv, and now I've got bond money, and I'm going to catch me a body tonight." And then he talks about seeing Mr. Barrow take a gun out and fire into the crowd. The fact that the jury didn't hear any of this, is the prosecution sweating?
Absolutely. I mean, that is some crucial evidence, crucial testimony I'm sure the prosecution was counting on to put the gun in that defendant's hands. At this point, the only thing they can establish as of right now is that a crime occurred, not that the defendant was the one that actually committed the crime.
Yeah, and let's not forget, so he was sentenced to 6 months in jail for contempt of court. He's already in jail because he's been incarcerated on child abuse charges. But he can't go back to jail for that until he serves the contempt. Have you ever had clients that are in this position where they refuse to testify and are held in contempt of court?
So I haven't had clients that have refused, but it is oftentimes when a prosecution witness will be uncooperative. Many states, including New York, have something called a material witness order, which is essentially what Florida has. You're subpoenaed. Whether or not you want to testify, the case is not against the victim. The case is against the state of Florida, the state of New York. And so you can be compelled to testify. You can be compelled to come to court. Now, once you're at court, you can't be forced to speak and testify, but then you could be held in contempt, which is what happened with this witness. And the punishment is jail time. This witness, for whatever reason, has decided he would rather spend 6 months incarcerated than testify.
What do you think? That's pressure? Do you think he really believes that these gentlemen didn't do it, that Mr. Barrow didn't do this, and it's a sense of guilt? Or if that's the case, couldn't he have just gone on the stand and told the truth and said, I made up my story to police, I didn't know what was going on? Or is he some sort of pressure? Is something more nefarious happening?
So that I can't possibly know. But what I will tell you is...
Speculate, Brian, speculate.
Yes. But what I will tell you is what's probably going on is, had the prosecution had this testimony that you just talked about under oath at a pre-trial deposition during the discovery phase, then they could have sought to do something called a certiorari hearing. A certiorari hearing allows you to put in previously taken testimony under oath and not be subject to cross-examination if the prosecution can show the reason the witness is unavailable or not willing to testify is because some nefarious conduct by the defendant. If that were the case, the prosecution would be fine and they'd be able to submit this previous testimony. But it's not sworn.
Not the case. Yeah. I want to show our viewers actually what happened in court with Christopher Jones. In case you missed it, it was really some of the more dramatic moments of this case. And again, as soon as we do have a live feed in the courtroom today, we'll make sure to turn right to it. But here is yesterday with Christopher Jones.
This young lady, raise your right hand, please.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Have a seat. Sir, can you tell me your name? Mr. Jones, do you understand that you're under subpoena to give testimony in this proceeding? You received a subpoena?
Yes, ma'am.
Okay. That subpoena means that whatever you say here cannot be used against you to prosecute you for any sort of offense. Do you understand that? But it also means that you have to answer questions. And that if you were to refuse to answer questions after being given the subpoena, that you could be held in contempt of court.
That's fine.
And that you could be sentenced to jail.
That's fine.
Is that your intention?
Yes.
You're not going to answer anybody's question?
Not one.
Not one. Just right in front is fine. Mr. Jones, raise your right hand, please, again. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Tell me your full name. So that's not true? Do you understand, sir, that you have been served with a subpoena requiring you to give testimony in this proceeding? Do you understand that I am now ordering you to testify in this proceeding? You don't understand that? Well, I'm telling you that you have to answer the questions of the attorneys. You're refusing. Do you understand that refusing to testify after being ordered to do so by a judge would subject you to a potential contempt citation? Okay. Well, it means I can sentence you to jail, and without a jury for up to 6 months. Do you understand that? Okay. I'm ordering you to testify. Will you testify? Can you show me any reason why I should not hold you in contempt of court? But you can't demonstrate any reason for me not to hold you in contempt. The court finds you to be in contempt of court. You'll be sentenced to 180 days in the Marion County Jail. You're going to serve that before you return to the Department of Corrections.
Well, you gotta love it. I mean, you can't make this stuff up. I think it was even more interesting when he said, Mr. Jones, do you swear to tell the truth? No, ma'am. And then he was sentenced to contempt for refusing to testify. I'm here with criminal defense attorney Brian Wagner. I love the dramatics of this case, Brian. That wasn't it for the prosecution, because also, later on in the day, Dentarius Bartley, who was one of the victims in this case, you would think he'd have such a reason to testify, talk about what happened that night. He said that he lied to police about what he saw. What did you think about that?
I think two things. One, it is often the case that a witness feels pressure to answer a question that they believe the police are asking. Whether or not this witness was actually pressured, we'll never know. My guess is probably not. But witnesses do often feel that pressure, and as a criminal defense attorney, you want to explore that. What suggestions were made to a witness? But on the other hand, given Mr. Jones' refusal to testify, and now given this witness's reluctance to testify to what he previously told police, whether or not they are being influenced by anyone, whether it's the defendants or a defendant's family or friends, we'll never know.
See, but here's what's interesting about it. So he said that he's one of the injured people. He said that he lied to the police. He said, but he failed to indicate how he was pressured. And he said that when he was in the hospital room is when the police were coming to speak to him. But the records indicate that he was alert, he was coherent, he understood what was being asked of him. So it's not clear exactly how he felt this pressure. I think at one point he did say that he positively identified Barrow after the fact he saw news reports about this guy, and that he felt the need to positively identify him after what happened. I mean, what do you think of that?
Well, as it turns out, the news report came out 4 days later after it. So as a former prosecutor, what I would say is it's probably not truthful.
Right.
As a criminal defense attorney, what I will tell you is whether or not it's truthful or not, I know the prosecution's case has a big problem that they either need to overcome substantially to prove their case beyond a reasonable doubt, or they're going to be left with being unable to prove beyond a reasonable doubt that these defendants were the ones that actually committed the shooting.
Yeah, I mean, he originally told police that he saw Laquan Barrow firing those shots. He felt that he might have been shot in the back by Mr. Barrow, and really important testimony, but since the jury didn't hear that directly from him, prosecutors were forced to have a police officer testify to the interview that he had with Mr. Bartley. Now, that's not as effective, right?
No. In fact, I'm surprised they were able to proffer that testimony, because if you are having a conversation with a police officer, the police officer typically cannot testify as to what that witness told them, unless it's being offered for something other than the truth of the matter. And so if you say it was Brian Wagner, a police officer can't then testify that I spoke to Jesse Weber and Jesse Weber told me it was Brian Wagner. It's hearsay, because you can't confront that witness.
Right.
The person that actually spoke and identified Brian Wagner.
Right. So if you're the state and your two key witnesses have now not given the testimony that you were looking for, and you heard another witness testify yesterday that they saw Barrow run to a dark-colored vehicle, retrieve a handgun, and begin to shoot. I'm sure you're going to have other witnesses, but when you really relied on two witnesses who at least made up their stories, or two witnesses who have recanted their testimony, what does a prosecutor do in this case? They have a late-night meeting. What do they say? Okay, we need to switch our whole game plan here. What do they do?
So that's exactly it. I can't imagine the prosecutor is completely shocked by these change in testimony. They must have spoken to these witnesses before and said, we're going to subpoena you, we expect you to testify. And in that meeting, the witnesses either said, I'm not testifying, or if you put me up there, I'm going to lie. And they basically called their bluff. And now in this instance, the prosecutors come out on the back end of that, really hurt their case. But I imagine that they have a backup plan, whether that be video surveillance, cell phone footage, other witnesses that they didn't really intend to call, but now have to call. But my guess is that the prosecutor has a plan B, and that's what they're going to rely on. Whether or not it's going to be as strong and substantial as their initial plan, we'll have to wait and see. But I'm sure they thought this was a possibility.
Right. I think that cell phone footage or also this videotape surveillance footage from the nightclub is really going to be key here. It's either going to support or contradict witness testimony in a very interesting way. But the rest of the evidence that we heard yesterday, the fact that there was no DNA or fingerprints on the shell casings, the fact that the crime scene analyst who testified, she saw she collected that there were 2 bullet holes in the side of the club, but she couldn't tell if that was actually from this incident. Maybe it was from years before. She couldn't even tell which direction the bullets went. Not a strong day for the prosecution. So when you take it all together, what do they have so far?
So there's, and I've said this before, there's 2 defenses to this type of case. It's a justification. Yes, I did it, but I was allowed to do it because I was self-defense, defense of someone else, or it's mistaken ID. Yes, this terrible shooting occurred, but it wasn't me. And it's pretty obvious that the defense in this case is the mistaken ID. It's, yes, this terrible thing happened, but it wasn't us. And the defense is doing a good job so far based on the lack of identification testimony that the prosecutor has not been able to produce.
I think the strongest thing for the defense yesterday, for the prosecution yesterday, was the 3 guns. So we were able to determine that 3 guns might have been fired in this incident. The shell casings came from 3 separate weapons. You do the math, 3 guns, 3 defendants. It's looking stronger for the prosecution in that respect because the idea that it's now, each one of them is saying they didn't do it. It's not like they're blaming each other. Barrow's saying King did it, King said Smith did it. No, they're saying it was 3 separate shooters, not them. And we knew that gunshot residue found that there was 1 particle consistent with gunshot residue on Barrow's hand. But at the end of the day, is that going to resonate with a juror so far, the 3 guns, 3 defendants?
I'd be shocked if it does, because the issue is not whether or not a shooting occurred. We know a shooting occurred, and whether it's 3 guns, 15 guns, or 2 guns, it doesn't matter. A shooting occurred. Now, just because we have 3 defendants lined up doesn't mean they each owned one of these guns on the night that the shooting occurred, or not even owned, touched one of these guns and shot one of these guns. The issue is, were they the shooters? Not if a shooting occurred. If all they had to prove was that a shooting occurred, yeah, then they probably proved it. But they have to prove that these people were the shooters. And I think without that ID testimony, it's going to be a hard road to travel.
I want to play right now the testimony of Dontarius Bartley, which we talked about, one of the surviving victims in this case. Really thought the state thought that he was going to be a key witness for them. Didn't turn out exactly as they would have hoped. So I want to play a little bit of his testimony right now as we do wait for a live feed in the courtroom.